a specific type of work permit, which is the C10 application, significant benefit application. In one way, you could say that it's one where if you can't fit someone under other LMIA exemptions, but you still think that you should do the LMIA exempt, you could go this way if you think you have the facts. But I mean, if you think it's going to be pushing it, then you should do the LMIA application. And I'll give a few examples after I explain how it works. But it is really, it's a high standard to be able to prove a C10. That doesn't mean that it's the most complicated application to do. Sometimes it's very obvious that you have a C10, but sometimes I do find that some people kind of, as I say, tend to abuse it. So I provided you the link to the program delivery instructions there. And basically, this is a type of application that you do when an LMIA is not available, and it's impractical to do an LMIA application to apply for a work permit. So basically, like, you could technically try to do an LMIA, but it's not practical. Given the kind of person that you bring into Canada, it just doesn't really make sense to just post that you're looking for anyone because you want to bring this specific person. Okay. The applicant must prove that there's social, cultural, or economic benefit to Canada on issuing the work permit, and that this is clear and compelling. So there's clear and compelling evidence that there's going to be the social, cultural, or economic benefit to Canada. Significant means that the benefit must be important or notable. So again, not to just use it with any kind of applicant. This is a significant thing. And then sometimes it's used as a last resort within reason or to maintain worker status in cases where there's imminent that the applicant will soon obtain other status and disruption of work will be very prejudicial. But again, not for the sake of abusing this provision. So let's do some examples. One of the recent ones that a couple that we did this summer, we had world-class thoroughbred horse jockeys from the US coming to race at important horse races in Canada. It didn't, I mean, so this one is an interesting one, and I'll tell you how we arrived at this conclusion. Normally, if you're bringing an athlete, as would be the case of a horse jockey, to race a horse in Canada, and there's exemption from a work permit. So for athletes, there's exemption from work permit, so you don't actually need to apply for a work permit. The thing, though, is that if they're racing a Canadian horse, is different than if they're racing a foreign horse. So if you're bringing a jockey to race a US horse, that's fine, work permit exempt. If they're racing a Canadian stabled horse, so a horse that's based in Canada, then they do need a work permit. There's some LMI exemptions for the Western provinces, and that is provided in a separate slide here under those unique provisions. In this case, they do need a work permit. And now when you bring this kind of like high-level athletes and they arrive at the airport, most of the times they don't really ask them much. And we've actually had circumstances where we prepare a C10 application and they arrive at the airport and they just let them in. They don't really ask many questions. So sometimes it's good to have it just as a backup. But I mean, if they do get into trouble and like they don't get in, like, I mean, your client, the employer could be basically like losing a very important race. So that's why it's important to do the application anyway. So in this case, I mean, if you have the example that I'm giving, foreign jockey coming to Canada to race a Canadian horse and they don't fit any of the exemptions of the Western provinces, they do need a work permit. Now, the thing though is that it doesn't make sense to do an LMIA because you're not just going to put like an ad saying just like, I'm looking for a jockey to race my horse as a Queen's Plate, for instance, which is Canada's biggest thoroughbred horse race. You need that specific jockey because that is one of the top 3 in the world or one of the top 10 in the world. And that jockey has been racing your horse in the US. So they have a rapport with the horse. They know the horse well. So you need that individual. That individual is the one who's going to win you $1 million or not at this race, or is going to help you win $1 million at the race. So that's one of those cases that's perfect for a C10. Someone who's going to bring economic benefit not only to the employer but to Canada, and having that person who's very well known around the world race in Canada, it's going to bring prestige to the event, and an event that's already well known. So that's the kind of situations where we use the C10. And it's not like anyone that you can bring. You need to bring this specific person. How do we show that they fit the C10? Well, we get a lot of articles that talk about this person. We get information about the awards that they have, how well known they are. We get letters from the employer talking about them, talking about the how they've been racing the horse, the chances of the horse winning this race. We get letters from people at the racetrack talking about this jockey and like the prestige that this person's going to bring. And this is like a perfect application for that. I mean, we've done this with world-class dancers like ballerinas. Now there's other LMI exemptions that could apply to them as well, and we'll talk about some of them here, the reciprocal employment ones. But this is a good example of a C10. Sometimes with some executives, there's success with bringing them because like they're a very well-known executive who's coming to run this company. I mean, like scale it up, and that's going to be an important benefit to the Canadian economy. We've done this with very well-known academics who come to work for think tanks here in Canada, or they've come to work for organizations. So people who are very well-known in their field, they have a lot of awards, they've written academic papers. Most people recognize them. It's the kind of people that, like, I mean, if you Google their name, you're going to be able to see a lot about them. They're good examples of C10 candidates because they're going to be bring social, cultural, or economic benefit to Canada and the employer. So not only the employer, but also Canada. They're well known, and you're not bringing this person just because you need a jockey, just because you need a ballerina. It's because you're bringing this particular person. There's no point in putting an ad because you need this person to do this job. So that would be like the perfect C10 candidate, right? And again, they don't have to be the most famous people around the world. They could just, but you need to be able to show that they are quite recognized. And on the next slide, we'll talk about what you use to show this. Now, there's another case when we've used this with, I would say, varied success. Many times we're successful, sometimes we've been unsuccessful. In some cases, because I find like the IRCC officer didn't read the application. They just like, whoever was doing the completeness check jumped into a conclusion that it didn't apply when that was really not the case. And sometimes because, I mean, they feel like we don't meet their requirements. And this is when we have someone who's not that very special and well-known person, but someone who has a work permit in Canada. We can't find another LMIA exempt work permit in Canada, and doing the LMIA and all of that would be like very impractical. And we want to be able to get them some time working while they become a PR. So I'll give you an example of something that we did. We have someone who's on the express entry pool, hasn't been invited yet or hasn't submitted a permanent residence application yet, but has a competitive score to be invited. Or another example, has a provincial nomination application in process, and that will likely go through. Now, because they're not already a permanent residence applicant, so in the case of express entry, they need to have applied for permanent residence already to be able to get a bridging open work permit. Or in the case of a provincial nomination, they need to have received the nomination, applied for permanent residence, and once they get the acknowledgement of receipt from the from IRCC, if it was a paper application, that's when they can apply for the bridging open work permit or another type of work permit. So if we can't do any of those, but it's pretty obvious that this person is going to get a permanent residence sometime in the future, and it would be very detrimental for the employer to have this person lose their status as a worker, that's when we've tried a C10 too. So we've done it with a few people who are working on very important projects for their employers. Obviously, the impact of them not working on those projects was significant economic prejudice to the employer. But these people were not well known, or like if you Google them, you wouldn't find out who they are other than maybe their LinkedIn page and like their Facebook page or something like that. But again, them not working for a short period of time until they were allowed to apply for a work permit or they actually obtain their permanent residence would be detrimental to the employer. That's when we've used C10. So again, this person will get permanent residence in 6 months or less. Not working in the meantime is detrimental to the employer. So we've kind of used the C10 there when we can. if we're not able to do a bridging open work permit, or let's say a provincial nominee work permit or something like that. That's a circumstance where we've done the C10 with, I would say, varied success. Sometimes it's worked, sometimes it's not, and sometimes I find the person who does the completeness check says, oh no, this requires an LMIA, and refuses the application before actually assessing the merit. How do you prove? So other than the example that I just gave, where you would actually we include a lot of information from the employer showing the project and how detrimental it was losing this person for a couple of months, how would you prove the athlete, the famous ballerina, the famous academic, that there's someone who's going to bring significant benefit to the Canadian economy, culture, or society? Well, according to the guidelines, officers should rely heavily on the testimony of credible, trustworthy, and distinguished experts in the foreign nationals field and objective evidence. So not just a letter from the employer or the individual saying, I'm the best at this. We're talking about awards, we're talking about publications, we're talking about letters from other people. And obviously the foreign nationals' past record is a good indicator of their achievements. It's helpful to show that the applicant can immediately be recognized as a leader in their field. And then the guidelines provide some examples, and I've kind of provided that to you with some made some modifications. Their academic records. So if you're bringing a very famous scholar, include copies of their PhD, their postdoctorates, their degrees, diplomas, certificates that they have, evidence from current or former employers talking about like all their accomplishments, national or international awards, or like patents that they might have under their name. Membership in organizations that require excellence. Sometimes to be a member of an organization, you need to be very well known in your field. So like, for instance, one of the jockeys that we brought this summer, to be inducted into the Hall of Fame, they need to be very, very good at what they do. And basically, so just the induction into that Hall of Fame is something that shows that they're a very distinguished person and someone who's going to bring a lot of merit, a lot of prestige to whatever race he's involved in. Leading role in an organization with a distinguished reputation, having been the judge of the work of others. Significant contributions to the field, but such as and scholarly, scientific publications. So things like that. That's how you would prove that kind of application. And again, you have to base it on who you have. There's people who are going to be recognized the second that they arrive at the airport. Maybe you don't have to like overdo the application. Maybe just some articles about them and some information about what they're coming to do in Canada is sufficient. There might be an academic who's not going to be recognized, but if you include in that application all of that information and awards and things and letters, then that's going to be much more likelihood of success. So document these applications well and don't overuse them. But they're an excellent alternative for when you really can't find an LMIA exemption, other type of an LMIA exemption, and it really makes no sense, even if you have the time to do an LMIA. I mean, if you're bringing a very famous dancer to Canada for 4 months, you're not going to just advertise for a dancer. You need to bring this person, and this person coming to Canada means a lot of ticket sales. It means a lot of reputation to this dance company having them here. Any questions about the C10 generally? Or any experiences? Someone has used it for something else and they've had success. If anything, let me know before we move into the C16, which is the next one, the Mobilité Francophone, or the Francophone Mobility Work Permit. No questions? Nothing about the C10? Okay. So the C16, I personally, sorry, let me just mute that. So I personally love this type of application because it's a fairly simple one. The requirements, the main requirement is that you need to have a Francophone person. So that not everyone speaks French, and they have to be outside Quebec. A lot of Francophone people want to come to Quebec, so you won't be able to use it there. But it's one of those that it's a fairly straightforward application, and I like using it quite a bit, especially because like it's so flexible when it comes to the position. It really doesn't matter what position it is, as long as it's considered professional and technical. So it's basically what the government is trying to accomplish here is that they want to increase the French-speaking population outside of Quebec. We've seen this in permanent residence programs that provinces have for Francophones. We've seen this in how Express Entry allocates special points to Francophones in addition to the points that they would get for having French and English as their languages. And this is like a good way to bring a lot of people to Canada. Basically, they need to be destined outside of Quebec. They need to satisfy the government that their habitual language of daily use is French. Or in some cases, if we don't have that, and I'll give you some examples, then include evidence that they do have a CLB7 in the TEF exam. I guess you could also use the TCF or the other one that IRCC is allowing lately. Now, what is this habitual daily use of French language? So if you have someone from a Francophone country, even if they're living in a non-Francophone country, that normally is fine. So if you have a French citizen who's been living in the US, they were educated in France, I feel comfortable doing that without evidence of the French language. If you have someone who lives in Morocco or Lebanon and you can show that their education or their work is in French, that's good. If you feel that this is going to be limiting, that you're not going to have that evidence, then do the tests. So get the CLB7 in the tests. We've had to do that with some clients who might have had some education in French in the past or some work experience in the past, but they were not from a French-speaking country and they were living in a non-French-speaking country. So we said, okay, just write the test. And then that's an easier way to go about it. What we've seen in some applications is that when the officer is not convinced, they do ask for that, or they actually have an interview with the client. So we had a client who applied. He actually was from Morocco. We didn't include the evidence of the French exam, and they just called him for an interview. And the main purpose of the interview was just to interview them in French and see that they had like a good level of French. So that's one of the requirements. And the other one is that the position must be a NOC 0 A or B. But again, this is pretty flexible, right? So it can't be a C or D position, but it could be anything that's managerial or A or B. And there's no requirement that the position actually needs to be in French. So you could be bringing technically a hairdresser, you could be bringing an administrative assistant, someone who's coming to manage a company, not speak French at all at work, and then you can use the Francophone provision. I mean, the idea is that since they're Francophones, they're going to be speaking French at home, or they're going to increase the Francophone population in Canada. But that's a great thing about the position, that you don't even have to make the argument that it's a bilingual position or anything like that. In many cases they are, but it's not necessary. And to answer Thomas's question, so you just really need to prove the CLB7. Yeah, to some extent, yes. So we've done that with some people who are, let's say, from Latin America. They're not Francophones by birth. They're not living in a Francophone country, but they have a very good level of French. So we've done this. But I prefer, when I do this application, to build as much as possible how this person uses French habitually. And normally it is because of the education that they had or the work experience that they have, or sometimes they work at a bilingual job. So if you have those factors, then include them as well. Question, do they need to pay median wage? No, not at all. So that's the good thing about most of the LMIA exemptions, right? You don't have to pay median wage. The only caveat to that, or the only warning that I make is, again, make sure that they don't think that the offer is not legitimate because of that. If you're bringing an engineer from a French-speaking country and you're paying them $30,000, most likely an officer, is not going to refuse it because it's not the median wage. They're going to refuse it because they're not convinced that this is a legitimate offer as an engineer. Okay. And so, so those are, again, very flexible. NOC 0 A or B, outside of Quebec, Francophone. Or someone with CLB7 in French, very good way to get them an LMIA exempt work permit. Now, Something else, okay, sorry, this is in the previous slide. There used to be a recruitment that had to be done to participate in this program, and it was more difficult than at that point to do it. So at first, it used to start with like some expos or like job fairs that took place in France and in different places of the world. People had to participate in those to be able to qualify under the program. So, I mean, those jobs were to find people employment, but they could have found employment somewhere else, but they still had to participate in those. Then later on, what the government said is that, okay, we're asking too much. We'll have people either participate in those fairs, job fairs, or the employer send us an email to the Canadian visa office in Paris and say that they're interested in bringing this employer, and we would give them the go of whether this position meets the requirements. So you actually, for some years, had to do that, had to email the visa office in France and say, we're thinking of doing this person. We're not participating in any expo, but we are interested in this person. And then you would always get the yes from the visa office. So that was fine. And then now they've eliminated that. So you don't have to show any recruitment efforts or participation in any of those, or email the consulate, the Canadian embassy in France in advance, nothing of the sort. Place of application, so this has changed. It used to be a hard rule that the first permit always had to be outside of Canada, at a visa office outside of Canada. Most of them would be processed in France, but some of them were processed somewhere else. I still recommend that people do this if it's the first C16 application and they're from a visa specific, so visa required country. The instructions, so the new instructions, and this is as of this year, they provide that they can apply the port of entry or within Canada for the first time, but they need to be prepared to include language results in their application. So if you have someone apply abroad, they went to a French school, they live in a French country, no need for language test, that's normally fine. And again, if the officer isn't sure, they might call them for an interview. If you're sending them to the port of entry because they're visa exempt, or they're in Canada already, I think you should include the TEF or TCF test results and show a CLB7. That's what the instructions provide. And renewals can be done within Canada. So renewals are fairly straightforward, not much of an issue. You don't have to prove the French level because they've already had that permit in the past. So there's not much